list of proofs for your position. You've got so many proofs or so many positions that you've got to show. Let's just take a little, a couple, 3 examples here and see if I can think of them. You don't have a driver's license, registration, and proof of insurance. There's 3 issues, okay? Now, you're going to have to show through witnesses and testimony that either you're not a person required, you're going to take the witness stand, you've got other witnesses that you're going to put on. There's so many things that you need to prove, that you need to show. In other words, I want to show that I'm not a person who's required to have a driver's license. And as an expert witness, let's say I'm going to bring my friend who's an attorney and I'm going to bring him in to testify on the law. What does he know about the law? All right? They may or may not allow that kind of testimony. It's hard to tell. But you can testify, he can testify, or if let's take another example, one that we know that we can get in, because depending upon the court and depending upon the judge as to whether or not he's going to allow it in, you got to test and probe, like the communists, you poke until you hit steel and then you back off. And I always poke. I'll try to ask all kinds of questions and let them shut me down. We're not going to allow that in. Well, I object. I think that should be allowed in. However, on radar, let's say, as an example, you want to get some information, so you get this guy on the stand, and what you're trying to show is, the objective that you're trying to show is that the Doppler radar is used by the police, if it's not used properly, is inaccurate. And you're charged with going 10 miles an hour over the speed limit, and you need to get out of the expert witness such things as, if it's moved, if it's a portable one like this, or if the wind is blowing, or if there's a neon light around, or something like that, it will affect it. And then you need to get admissions and confessions out of the policeman that, he was moving it as you were going by, that he was sitting right under a neon sign, or that the machine hadn't been calibrated for the last week. Okay? That's your objective. All right? So you write down your objectives that you need to show. If it's radar, well, then you need to show that 5 or 6 things here. That the radar is inaccurate, that the radar is the Doppler, and you're going to ask the policeman, what brand is that? Well, it's a Zenith. And does it work off of this principle or that principle? Well, it works off of this principle. In other words, when you have in mind the goal that you're looking for, you can sit there and work toward that goal. You may not achieve it. I've had witnesses on the witness stand, and I'm saying to myself, now I need out of this particular witness these admissions and confessions. And if he's a clever witness, which is especially true if you've got a judge or a prosecuting attorney on the witness stand, and these guys are paid professionals, you can sit there and try to get it out of them. You just can't do it. And I see the frustration they go to, because sometimes they'll get me on the witness stand, and I'll just sit there and play cat and mouse with them for an hour at a time. They want to know, what property do you own, or where do you own it, or whatever it is, and you're just sitting there, property? I own a lot of property. What property do you want to know about? I want to know about your real estate. Oh, okay. How much real estate do you own? None. See, the word own is the key word. I don't own any. I have some equitable interests in some real estate, maybe. Well, and then maybe they'll pin me down, Well, do you have any equitable interests in any real estate in Ada County? No. I don't tell them about my equitable interest in real estate in Miami, Florida. See how that comes down? In other words, and they're going to do that to you. And so what you've got to do then is you've got to be crafty and clever and devious enough that when you start getting answers like that you pin them down item by item. And so in order to do that, you've got to have a goal. You've got to say, I want that policeman to admit that he was moving that radar. Okay? So in order to get him to admit that, do you want him in before the expert witness or after? Do you want him in the courtroom while the expert witness is testifying? Or do you want to exclude all witnesses from the courtroom? Those are decisions that you want to be thinking about and making up in advance. Sometimes, like in my case, I'm running a school, so therefore I'll announce that I'm going in, I'm going to argue a case. And I will bring my students in and let them all sit down. The courtroom is all filled with people. And some of the witnesses also want to be in there, and I say, well, is it really necessary for me to exclude witnesses today? Because if it is, well, then I'm going to have to send these students out in the hall. I'll just have to tell them, sorry, but you're going to have to sit out in the hall because I need to exclude my opponent's witnesses, so I'm going to have to exclude everybody. All right, so those are the things that you need to be considering. And you don't want to be considering or thinking about those things in a hurried fashion while you're in the courtroom and you're trying voir dire and you got all these things going on. Because let me tell you, when that trial comes down, the day of trial, boy, that judge, he's got that freight train on the track and it's wide open and he wants that trial completed today. And why? Well, because he's got things scheduled for tomorrow and the day after. He's got other trials. He's an administrator. And that prosecutor wants this thing done today because he's got other trials and things to do tomorrow. And you can't go in there and obstruct the court. I don't blame those guys for wanting to hustle. But on the other hand, it's not my fault if they only schedule 2 days for a 4-day trial. No, I've got my things here to do, and I'm sorry, Your Honor, but I noticed the court up that I was appearing pro se, and the court knows full well that I'm here pro se, and I've had them ask me, well, how much time is it going to take? Well, I don't know. I've never done this before, I'm kind of new at this, but whatever you think. Well, I think this should be done in 2 days. Wouldn't you agree, Mr. Gordon? Well, I don't know if I agree or disagree because I'm not really that expert at it. I haven't been to law school, but if you think it'll take 2 days, I'll go with your judgment, Judge. See what you do? Never let them pin you down to say, well, yes, I can do it in 2 days, because then they're going to hustle you. You can always say, well, don't rush me to judgment. I'm doing the best I can, and I've got 18 witnesses, and you knew I had 18. You signed the order, and that's the way you've always got to handle yourself when you go in there, okay? So the list of proofs for your position may be 18 long. You may have 18 proofs or 18 positions that you're trying to advance and show from your witness and from hostile witnesses. You may want to, subpoena in 5 police officers, and those police officers are hostile witnesses, and they don't want to make admissions and confessions on that witness stand, and they're really going to do everything they can to keep from telling your side of the story, what happened, why it happened, what their motivation was, and they're going to lie. Policemen invariably lie. I don't know if everybody does, but, it's been my contention for a long time that everybody's a liar. I think I've covered that in past lessons. Nevertheless, the policeman, he's on there and on that witness stand, and they just lie. I don't know why that is. There's only 1 or 2 policemen that I can think of that I got on the witness stand that told the truth from beginning to end. And they're really disappointing that way because, if they'll sit there and tell the truth, it can actually hurt your case. Because if you're trying to show that these policemen over here are devious and lying and that their testimony contradicts other evidence and facts from other witnesses, and they get in there and tell the truth, it hurts you. And that's why I like policemen to come in and lie, because remember, the other policemen are sitting out in the hall, aren't they? And just to illustrate the point now for this little segment of this lesson, have you ever played the game where you whisper in the next guy's ear, kind of a little parlor game, and you whisper in the guy's ear and you tell him a sentence, and the sentence may be, George Washington's white horse crossed the Delaware River on a boat. And you pass that statement around to about 5 or 6 guys, and the last guy, he says, now what did you hear? Washington's horse crossed the river, swam the river, and came back on a boat. It will not be the way the sentence was first stated and the way it's written down. Okay? I don't care if you've got 10 witnesses who actually saw what occurred. They cannot relate the story the same way, and that's what cross-examination is all about. And when we get over to cross-examination, we're going to spend a lot of time on cross-examination and asking and answering questions. But nevertheless, you want those policemen to get in there and one guy tells his story, and then here's your clean yellow tablet, and you go down that list over there, and you write down what it is he said. Take your little notes over here. But you're not going to be able to ask those questions unless you've got them written down in advance. And so you write down the 40 questions for Officer Smedley. And Officer Jones come in and you ask him the exact same questions, and the jury will pick right up on that. And the record, of course, is going to pick up on that. And the appeals courts, when they see that, here's 40 questions for Officer Smedley, 40 questions for Officer Smith. When Smedley answered that question, he said thus and so. When Smith answered the question, he said no. Smedley said yes, Smith says no. The third officer comes in. What does he say? Yes, no, I don't remember. What does the fourth officer say? It seems to me that I think that but no. Okay, two guys no, one guy yes, one guy doesn't remember. And you go down that list of 40 questions and you'll get 5 lies. Now you bring Smith and Smedley back in one at a time. Zero in on them. Do you understand the penalty for perjury? Have you related the truth? Have you thought about this? Do you want to change your testimony at this time? And now he knows that the other guys came in, but he doesn't know how they answered that question. And all of a sudden now he's panic-stricken. Well, yeah, I forgot. I don't remember. No. You said yes when you first answered the question. Then you said you don't remember. Which is it? Is it that you have a bad memory? Aren't you trained in the law? Aren't you trained in police work? Aren't you a professional witness? Is this the first trial you've ever been to? Have you ever testified before? Why is it that your story changes every time you come into the courtroom? In other words, you see what you're doing to that guy, you hammer that guy. And the jury's sitting over there, and whether the jury can comprehend or understand it or not, I don't really care. But I'm setting the record. And I'm going to show the appeals court, I'm going to show the Supreme Court of the United States that 5 officers are using me for malicious prosecution. They don't like me. They've seen me before. And they brought this prosecution, these charges against me because my name is George Gordon, because I'm on the streets and they don't like it. See what you're doing to them? We'll cover that more when we cover cross-examination. But your cross-examination isn't going to be worth beans if you just go in there and you start asking questions and then you can't even remember whether you asked this question or not. And there is no way in the world that you can ask the same 40 questions in the same order to the same 5 witnesses who were there and saw it unless you've got those 40 questions written down. It just isn't going to happen. And you know, one of the biggest things that I see that citizens fail to do is to write. You've been to the government schools and you can't write. People don't write letters. They pick up the telephone. And they can't write. You know, I've got students that come in here, they print. I mean, they're 24, 30 years old, and they'll sit here and they'll print. Now, I feel sorry for people like that because they're really functional illiterates. And remember that in the courtroom, everything is done in writing, and if you can't write, boy, you're in a world of hurt. Okay, so you can only print, then print the questions out. That's the way it's got to be. And if you're not willing to do that, the quality of your performance is going to be inversely proportional to the effort that you put into it. If you put a little bit of effort into it, you'll get a little bit of results. But they'll keep coming back on you because you're easy to beat. And you don't have good groundwork, and you don't have good factual appealable issues. All right? Now, you've covered your witnesses' questions, the jury questions, you've got your subpoenas out, you've got your list of proofs that you need to prove, you've checked your file, you've got every motion in there, you've got every affidavit that you want in there, and you've covered everything, and you say to yourself, all right, now, what's missing? Now, there is wisdom in a multitude of counsel. That's an old proverb that comes from the Bible. It's mentioned several times. I use it constantly. I think the book of Proverbs is one of the better books that a person can read. You ought to read that book once or twice a year just for funsies, and you'll see just how much wisdom and information and just plain common sense that you come up with. So here's what I do. I'll sit down in a circle, you know, with coffee, and we call this coffee and laugh time, and I'll sit here with our engineer Ted or with Bob or somebody, and I'll start laying out some questions and issues, and I'll ask some questions, and Bob will say, well, did you think of this or that? And you'll be amazed at the input that you're going to get by just talking to 4 or 5 other fellows. Start at the scene of the crime and say, this is what I did, and here's what he did, and here's what happened, and then there's what happened. What about this case, and what about that case, and did you think to do this, and did you think to do that? What about so-and-so over here? And pretty soon, you'll start writing down more things for your checklist for you to cover. questions to ask of the witnesses, other witnesses that you had not thought of, questions to ask the policeman, expert witnesses that you may call. And remember, this isn't 2 or 3 days before trial. Now, this is 2 or 3 weeks before trial that you're going through this checklist. Now, when you get through with that, you say, wow, I've got 3 weeks. I've got plenty of time. I'm not hurried. You'll be amazed at how poor your performance is when you're in a hurry or when you're in a panic. I've got to be at trial on the 9th, and I've got 4 days. You know, I'm sitting here before this camera right now, and I have an appeal that has to be in 3 days. And I thought I had 2 weeks, but all of a sudden I checked my calendar, and I've only got 3 days. And I'm under pressure. I mean, I've got to write an appeal. When I get off this camera, boy, I've got to sit down. And I've got to write an appeal, and I've got 3 days to do it. You see how much better it would have been to do this 2 weeks ago? But you know, I went through my checklist. I have a calendar. And on my calendar, I write all these things down. And when I walk into my office, I check my calendar. And I say, well, let's see, what's going on today? What's going on for the rest of the week? What do I have? Oh, my goodness, I have an appeal that has to be in by next Thursday. How could I be so stupid? But at least it isn't next Monday, and I'm not saying to myself, oh, I had to have that in last Thursday. Now I've missed my appeal. I'll concede that my preparation and plans are a little sloppy, but I'm not faced with disaster. I'm not faced with loss. Okay, now getting back to the talking this over with your friends and your consultants. Let's say you've got a little group of people working in Kansas or wherever you are, whatever it is, and there's 10 or 15 people. You don't necessarily need, and I don't mean to slight anybody, but if you want to go talk to the least knowledgeable, I don't think you're going to learn too much. I think you want to talk to the most knowledgeable people in the group. And this is a little difficult to do because of 4 requisites of human nature, and they're this: vanity, jealousy, lust, and greed. And human beings, just as a matter of natural makeup, hate to admit that that guy could know something that I don't know. There seems to be some kind of an innate, inherent competition among people pursuant to knowledge. If you can get over that kind of foolishness, as I call it, I think it's foolishness personally. I don't know everything. I can't think of everything. I don't mind sitting down with a group of other people and saying, what have I forgot? What is it that I need to know? What can you teach me today? There isn't a day that goes by that this engineer over here doesn't teach me something. You know, we'll just sit here and have a cup of coffee or be talking about something, and he'll just say, hey, I read this or that case, and I think it may be apropos to your position. Here, you should read this Supreme Court case, or you should be aware of that. I've had guys say, listen, Gordon, you're all wet. Your position over here isn't supported by the Supreme Court because the court says thus and such in this case over here. And you're going to go into court arguing this off-the-wall doctrine over here, and you're out to lunch and off the wall. Oh, I am? I'll take those notes down. And I'll say, well, now, Bob says that I'm off point here, and Neela says that I've forgotten this and such. And these guys really get critical. I mean, they get downright nasty. With me, they do. And, you know, around here, now I don't know about your little group, if you want to sit there and flatter each other with how great each and every one of you are, fine, go ahead and have at it. But you're going to be a whole lot better off if you'll sit down with a group of people that are more knowledgeable, your instructors, those that have been around for a while. The guy that's been in the courtroom 5 times is probably more knowledgeable and has a little something more to add. Even if he was in there 5 times and lost 5 times. At least he went in there 5 times, and now he can tell you, here's what I did that was wrong. This didn't work for me. There's no need for you to do this or that because, boy, that sure don't work. And, boy, I sent me to jail for 5 days for contempt for doing this or that. Watch out for that or watch this judge, and you'll be amazed. Another thing you'll find, too, in talking with a group of other pro ses. Yeah, I had that judge. I would disqualify her immediately. In fact, I just got a disqualification notice in the mail this morning on a judge that I disqualified simply because somebody else told me I should, because he'd been in front of her and said, in this type of a circumstance, I think I'd get rid of her. She's definitely prejudiced and biased against pro ses and citizens, and she's pro-government, and she's a real quack. And therefore, on this issue, since it's important that you get this issue qualified for the next court up, and you want to see if you can set some new doctrine before the court and get it into the record, I'd suggest that you can't pick one of the 7 judges, but out of the 7 judges, if I can disqualify her under Rule 40 for no cause, instead of 1 in 7, I've got 1 in 6. And of the 6 judges that are left, 3 of them are pretty good and 3 of them are questionable, and so I've got a 50-50 chance. With this particular judge, I've got a 0 chance. I got a bad judge. By eliminating that judge and taking on the advice that I received, I've got a 50-50 chance. I can't do any worse, I've been told, on this particular type of case. Okay? So since I can't do any worse, let's flip the coin and see if it comes up heads. Maybe it will. If it comes up heads, good for me. If it comes up tails, I haven't lost anything. Now, that's what you get when you take on or seek out wise counsel. It's a little humiliating. It's embarrassing even sometimes to sit there and be called down and called on the carpet. And this is especially true when you come out of a motion hearing. Never do I come out of a motion hearing or a trial that I haven't got 3 or 4 people sitting over there who are taking notes. And we sit down and have those people say to you, listen, why didn't you do this? Or why didn't you do that? Didn't you see me raise? Why didn't you motion for a 5-minute recess so that you could come back and talk to me? Why didn't you turn around and look at us back here? When I walk into the courtroom, this is what I always do now. I've learned my lesson. I'll have 2 or 3 of my friends sitting in the back of the room and I'll argue a motion hearing. And maybe I've been there waxing eloquent for 15, 20 minutes or an hour or whatever it is, and I've covered all these salient points, and boy, I've just beat the table, you know. I'll pause for a moment and I'll turn around and I'll have, you know, this is preordained. And if a guy gives me the high sign back there, I'll say, and Your Honor, I think I have a couple of more points, but I'd like to take a 5-minute recess here to gather my notes together and to present the summary to my position. The judge will give you the 5-minute recess. Once you've got the 5-minute recess, now what you do is you walk back and say, okay, now what did I miss? Oh, this, and this. Now you come back, and now there's 4 of you, or 3, or 2. There's 2 or 3 of you in there arguing your position. Not just you against him. Now it's 3 against that prosecutor over there. You see how important that is? It takes a little time, effort, and energy to get to that point in your life where you're not so, puffed up with vanity that you can't take anybody else's advice. I don't care. Even a student can be sitting back there and say, oh, Mr. Gordon, I thought you said thus and such, and you were going to bring up this or that subject. Did you remember that? Are you going to do that, or have you changed your mind? Hey, good point. Thanks for bringing that up. And you jot that down, and you bring it up in the motion hearing. Now, there's 3 more things that you need to be aware of in this trial that you want to have in your briefcase when you get in there. Okay, and that is your list of prima facie evidence. Prior to going forward to trial, you need to think through the prosecutor's position. How would you prosecute you if you were the prosecutor? So you write down prima facie evidence. What is it that the prosecutor has to prove? 1, 2, 3, 4, 5, 6. There are 6 basic elements that have to be proved before he can walk into the courtroom. And depending upon the particular case or the particular issues at hand, he may have to prove 10 or 15 more. So you say to yourself, well, if I was the prosecutor, I've got to show this, I've got to show that, I've got to have this witness and that witness, I've got to prove this, I've got to prove that, and you write all that down. And as he presents his case in the first half of the trial, you sit there with your checklist. Yeah, he proved that. Yep, he's got that covered. Yep, he covered that one. Wait a minute. He forgot this issue. He hasn't proved that. Good for him. Oh, he forgot that item. Hey, this guy's just fresh out of law school. He doesn't have the necessary evidence to prove that I don't have a driver's license. He hasn't checked. He hasn't put a single witness on the stand who can come in here and testify that George Gordon does not have a driver's license. You know, there's another issue that's really funny. It's the proof of insurance issue. And they'll charge you with failure to purchase insurance. And he gets all through with his case, and he hasn't put one witness from Lloyd's of London in South Africa to show that you didn't have an insurance policy from Lloyd's of London in South Africa.
or from Rio de Janeiro, Brazil. He's failed to prove that I don't have insurance. He's made the allegation, he's alleged it, he's got the policeman up there testifying, yeah, I asked him for his insurance and he didn't give me the proof of insurance and blah, blah, blah. But he hasn't proved it. All right? As soon as the prosecutor sits down, now you challenge the state's prima facie case. And you've got that laid out in spades. Okay? Prepared. Now, you're going to go to lunch, and when you go to lunch, you need to talk over with your advisors. Okay, now how's our strategy? Do I want to take the witness stand this afternoon? What do you think, Ted? What do you think, Bob? What do you think, Joe? Should I take the stand this afternoon, or should I stay off the stand? In other words, you've got an hour and a half now at the lunch break to make your decisions. Now you make your last-minute decisions and your preparations for your half of the case in the afternoon. Okay, now, you come back in the afternoon, you put your witnesses on, maybe you're there at 1-day trial, a 2-day trial, I don't know, whatever it takes, and you get all through and you got your trial laid out, and the jury goes out and comes back, they find you guilty. Do you have in your file folder here a stay of execution pending appeal? You better have it there, because what if in your state they can sentence you in a traffic case right then and there? In Idaho, they've got to wait 24 hours. I always motion up for a week or two so that I can file additional additional motions. And one of them is going to be a motion for verdict notwithstanding the jury. All right, what is that word now? A motion for a directed verdict notwithstanding the jury verdict. All right? You want that in your case. You want to have time to file it. You want to have it ready to file right then and there if need be. And you want a stay of execution pending appeal, and you want to file that right on the court. Your Honor, I want to appeal this case, and I don't want the execution or the case, execution, the fine and the jail sentence executed before I can have this appealed. And you've got a right to that. And so that preparation needs to be made prior to walking into that courtroom. All right, so if you'll notice here, what you're saying, what you're doing, and while you're saying it also, you're saying and you're practicing and you're doing a major case. You're prepared at every stage of the proceedings. And you're doing this with plenty of time, 3 weeks prior to trial, so that you're not walking in there ill-prepared. You know, almost every attorney that walks in, every prosecutor walks in ill-prepared, they're not going to spend 1/10 the time that you should spend on this case. And the reason that you're spending so much time on this case is because you're sending a message to the judge and the prosecutor in future cases that I'm not a pansy. You don't come over here and punch George Gordon in the arm, because when you do, you're going to pick yourself up off the floor bloody every time. Now, you're going to come back and whip me. I understand that. But every time you mess with me, you're going to come up with blood. You know, I tell my kids that when they get in a fight in school. Did you draw blood? I told my boy one time, he was getting beat up in school in about 4th or 5th grade, I said, if you come home without drawing blood, I'll whip you. You know, he doesn't have any more problems in school. And I don't know whether that's right or wrong or good or bad. I'm just telling you that's what works. You get in that courtroom and draw blood every time, and you're going to find that your government doesn't want to mess with you. The first time 2 or 3 out that you go in there, it seems like that they're just going to hammer you. It's a matter of who's got the greatest staying power. If that guy would have come back the 3rd day and punched me in the arm, he'd have picked himself up off the floor the 3rd day, the 4th day, and the 5th day. He'd have picked himself up off that floor until he left me alone. And that's the way that would have come down. I found out twice was enough. I find out that in the courts 2-3 times is enough. When they get enough, and they find out that you mean business each and every time, you'll find out you're going to get miraculous results. Well, there's the checklist. That's the checklist that I have for this lesson. But there might be 10 more things that I haven't covered today. Now, the objective of this entire course is to teach people to think for themselves. I find that all too often, people will sit here and take copious notes, you know, especially young students will do this. They've been to the government schools for so long that they'll copy down the 6 things that I talked about, and there may be 10 or 15 more that I haven't covered today, and more than likely they are, because depending upon your state, your locality, your case, what it is you're doing, there may be some other things that you need to be thinking about. The thrust of Lesson 20, then, is to put your case together in such a way that you've got a battle plan. I don't think that you would move to Texas. Now, I shouldn't say that because, people will just load things in their car and drive to Texas and look for a job. I've seen that so many times that I always shake my head and I go, I wonder what that guy was thinking of. I moved to Idaho some years ago, and I didn't move here accidentally. I didn't move to Idaho accidentally as opposed to Utah or Montana or Wyoming. I had looked at all of those states, and I decided that for me, in my particular circumstance, for my objectives and purposes, that it was Idaho. I came to Idaho 3 or 4 times, and I scoped it all out, and I looked at it, and I said, not just any place in Idaho is satisfactory for me, for my purpose, for what I want to do. Boise, Idaho is the place that I'm going to be. And I didn't come here looking for a job. I already knew what I was going to do when I got here. I had already set the plan in motion. Step 1, 2, 3, 4, 5. Okay? I noticed that there are very few people that I run across in my business life do that. And I don't know whether it's education or heredity or just the natural American spirit that they just throw everything in the car and drive to Idaho. And I've seen this happen, and they'll just get here and they'll take a job and they're just working here. Why are you in Idaho? Oh, I don't know. We just heard about it. Oh, did you hear that Idaho has a big unemployment problem? No. Did you check on it before you came? Not really. What did you do in California? Oh, I was a frogman. Oh, so you're a deep sea diver. Yeah. You having a little problem getting work in that line here? Yeah, I can't find any work at all here as a deep sea diver. Had you considered Seattle or Vancouver or San Francisco or any place along the coast or maybe gosh, that's a good idea. You see the point that I'm illustrating? People go into the courtroom as accidentally as they go into the job or the occupation. I'll bet you most of you people out there are probably married to the woman or the man you're married to accidentally. And I know I am. I just kind of accidentally, I got married when I was in love. I didn't think very far ahead, It worked out all right in the end, but it wasn't because I had deliberately scoped it out. At my age now, if I were going to get married again, I think I would sit down with a checklist and say, sweetheart, let me ask you a few questions. Let me see whether or not you and I are compatible and whether or not this contract is really going to work out in the long run. That it just isn't done. But what I'm suggesting is that I think that reason, logic, and common sense tells you that if you don't plan it correctly, you probably are not going to get the kind of result that you really want. You lay your case out with this kind of a battle plan, and I'm telling you, when you go into that courtroom, this entire episode will be fun, it'll be thrilling, it'll be exhilarating, and it'll be enjoyable the entire time. I just have fun. We're going to stop this TV here, this tape, and we're going to go up and have coffee and laughs and have a ball all day. I'm going to write my appeal. I'm going to sit here and talk about cases that I studied over the weekend, and other people are going to relate information and knowledge that they have to me, and we're going to have fun the whole time. But I can remember a time when I used to go into that courtroom without my battle plan, without the knowledge, without any good grasp, I couldn't write a battle plan because I didn't know what the battle was all about. I didn't even know what I was going to do. They just put me on an LST and they opened the gate and they said, charge and kill the enemy. I didn't even know what the enemy looked like, let alone what to do when I got there. And so I was running up and down on the beach firing my gun, and I never hit anybody, never did anything constructive. All right? That was an error and a mistake. What I try to encourage you and all of my students to do, don't do that. It's frustrating. It's a waste of your time, effort, and energy. You go into the courtroom and you run across these strategic defeats, and it's upsetting, and it just ruins your day, and woe is me, and blah, 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 and it's not fun. If it's not fun, you're not doing it right. Have the battle plan. The battle plan is what makes the whole thing so much fun.